Okay, ladies and gentlemen, Joy Stephen from the Paulinson Studios, and here is a case law for the Student Herald, Sandhu versus Canada. Now, case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters, and judgment for this case is attached in my blog reportersreport.com as a PDF document. It's an immigration case law and includes topics like selection and admission, sponsorship. Sponsor applied to sponsor his Indian spouse for permanent residency. Application was denied by visa officer on basis of concern that marriage was not genuine and had been entered into primarily to acquire immigration status. Board upheld the decision on basis of its own credibility concerns. Sponsor applied for judicial review. Application was granted. Matter to be redetermined on merits by different decision maker. Board's assessment of evidence was surprisingly shallow, and most of its credibility determinations were unsound and not supported by evidentiary record. Board's credibility concerns were limited to 4 discrete areas, not one of which touched directly on genuineness of relationship or its primary purpose. Determination of whether person's primary purpose for marriage is to obtain immigration status necessarily includes assessment of genuineness of relationship. 2 conjunctive aspects of S41 of Immigration and Refugee Protection Regulations of Canada are linked and must be considered together. There is also nothing inherently objectionable or suspicious about desire to seek out Canadian spouse in arranged marriage with view of family unification. Where both parties have bona fide commitment to long-term maintenance of marital relationship, it will be rare that primary purpose of marriage can be reasonably found to acquire immigration status. Primary purpose of bona fide marriage has to be long-term commitment to relationship. Collateral advantage of gaining immigration status would be secondary to that marital commitment. Very interesting case, Sandhu versus Canada. It's dated November the 23rd of 2015 from the Federal Court. Thank you.